One of the first cases I had as a young lawyer involved a corporate client. I was very excited to have this new client and went and filed a lawsuit on their behalf and was very disappointed when in the first hearing in front of a judge, my case got dismissed because I hadn't properly stated my corporation's name and place of legal existence. I was, of course, devastated when that old lawyer went into a courtroom and explained to the judge, Your Honor, he hasn't identified who this corporation is or what state they're located in. And the judge properly dismissed my complaint. I've never forgotten that stinging rebuke that I got, but it was an absolutely correct statement of the law. And so when I started doing foreclosure defenses, I've always remembered that lesson. And one of the things that's just so mind-blowing about what's happening in the space of foreclosure is that millions of Americans are being thrown into the street by corporations that we cannot identify. They may not even be corporations, as a matter of fact. We've got these shadowy trusts and these shifting entities and other legal organizations or maybe illegal organizations that we can't even identify. All of these trusts out there and special servicers and every alphabet soup that you can possibly imagine that are allowed to file foreclosure complaints and not properly identify themselves in court. One of the first motions that I ever filed in capacity was involving a corporation, a mortgage corporation, and I directed a motion to dismiss that. I said, Your Honor, they have not pled their capacity. We don't know who they are. And the judge looked at me, what are you talking about? There it is, and I believe it was Freedom Mortgage Corporation was the name. I said, yes, Your Honor. I went to Division of Corporations, but there were in fact 3 different Freedom Mortgage Corporations. One in New Jersey, one in Minnesota and somewhere, and then one in Florida. The point to be made by that was when they just pled Freedom Mortgage Corporation without specifying what state of incorporation the corporation was from, we had no idea what Freedom Mortgage Corporation it was that was suing to throw my client out into the street. And when you look at what's happening all across this country, they have these corporations, these entities, hiding behind corporate names and throwing Americans out into the street. I've raised the question again, and I'll do it all the time, which is to say, do we even know who it is that's throwing Americans out into the street? When we have these shadowy trusts that don't have a state of incorporation, they don't have a situs, the plaintiffs refuse to provide pooling and servicing agreements, the question we have to ask judges is, Your Honor, do you have any idea who it is that you're granting this piece of American real estate to? Do you have any idea who it is that you're giving millions of dollars worth of judgments to? And the fact of the matter is they absolutely do not. These corporate names, these NAs, these FSBs, these are titles or acronyms that are after the corporations, but they're never specifically laid out, are a violation of basic pleading rules that have been in our law since the beginning of our country. And so to allow them to continue with this practice in any way is improper. But what we see happening in the space of foreclosure is particularly disturbing because we have all of these entities that are filing bankruptcy and being consumed by one or the other, so that you have a corporation that files a lawsuit in 2008, and maybe they're in good standing at the time, but then fast forward to 2011 or 2012, and that corporation may very well be bankrupt and no longer have any authority to pursue a case, or frankly no longer be a corporation in good standing. These are things that we as defendants need to be able to challenge, and the only way to challenge that is if the plaintiffs are forced to plead the capacity of the entity within the body of the complaint. Now, I'm happy to say that at least in this area, judges recognize this and frequently will require them to do basic pleading. This is just sort of fundamental stuff here, but that's not the case across the country, and I have a feeling it's because people just don't understand the significance of what we're talking about. I frankly think it's a national security issue. We have to understand that in foreclosure, what we're talking about is granting real estate of the United States of America, the actual physical dirt of this country, is being transferred from one party to another. And darn it, if you're a judge and you don't understand and can't grasp who it is that you're granting that real estate to, you shouldn't be giving pieces of the United States away. And that's exactly what's happening here. Well, I'm happy to say that the appellate courts are picking up on this as well. Again, I've been pleading this capacity thing for a very long time, and finally appellate courts are starting to recognize the fact that we need to identify just who in the heck it is that we're trading America away for. Now, capacity and standing should be raised in virtually every case because I've yet to see them plead it properly. But the important thing to understand here is just yesterday out of the 4th District Court of Appeals, that's down around Broward County, they released an opinion called Elston versus CW Capital. Now, Elston versus CW Capital makes it very clear. It stands for a very simple proposition that if you're a party coming into court suing on behalf of another party, you are required to identify who that other party is. Now, this is capacity is basic corporate law. You have to identify who the corporation is. But in foreclosure, it goes one step deeper because you have not only corporate law, but you have agency and principal law. You have these situations where the agents are suing on behalf of principals, corporations that should be identified. And the problem is that in far too many cases, frankly, maybe in the vast majority of foreclosure cases, we have agents suing on behalf of principals. They're admitting that they are not the owner of the note or mortgage in question, but that they have the right to sue on behalf of another party. Well, that's fine. If you're coming into court, you're saying, I'm suing on behalf of another party. When a defendant challenges that, you have to prove or have to plead out who it is you're suing on behalf of. Now, I had this devastating trial back in February. We pled out that they asserted they're suing on behalf of another party. We said, that's fine. Tell us who it is you're suing on behalf of. They refused to tell us. We had depositions. We asked, who is it that owns the note and mortgage? They did not know. That's the testimony of the corporate representative. We go into trial, and that was one of the first points that I make was, Your Honor, they assert that they're here acting as a servicer. They assert that they're here acting to collect on another party. They need to show who it is they're here acting on behalf of. To me, it's just a basic element of law. If I'm going to go into court suing on behalf of someone else, and the other party says, you don't have the right to sue on behalf of that other party, surely the court would say, Weidner, you need to come up with some proof that you have the right to sue on behalf of that party. Let's take it in the context of an estate. If a personal representative or a testator under a will comes into court suing one of the other heirs, and the other heir says to the court, Your Honor, I don't think that that's the personal representative. My brother decided that someone else was the personal representative. Without question, the court would say, you need to come up with some proof that you are the personal representative if you're going to maintain a lawsuit. In a other corporate capacity, if there were a corporate shareholder dispute or something like that, and an officer of a corporation was bringing suit against anybody else on behalf of a corporation, and one of the defendants said, you know what, you need to prove that you have the right to act on behalf of the corporation, the court would absolutely require that party bringing that suit to prove that they have a right to sue anybody else or act on behalf of the corporation. And so why is it that in the space of foreclosure, when we're talking about throwing Americans into the street, if I as a defendant or an attorney representing a defendant demand that the plaintiff show that they have the right to sue on behalf of whoever the hell it is that they claim owns the note and mortgage, that they should not be required to do so? I'm pleased to say that the 4th District Court of Appeal says that they have to show that they have the right to do so. Now, this is interrelated to another concept, and that is this fantasy, this fiction, this lie that's being perpetrated across this country, where they're saying that these promissory notes are negotiable, and all they need to do is come into court with that original promissory note endorsed in blank, even if it's a fraudulent or forged signature, and they have the right to sue and throw my client into the street. That's absolutely not true. The mortgage industry did not intend to make these notes negotiable so that, as they are inclined to say, anybody can come in court and enforce a note, even a thief. Absolutely not. That's not what the mortgage industry intended. When they put these deals together, they intended the note and the mortgage to travel together along with the assignment of the note and mortgage, along with the pooling and servicing agreement, and the other documents that go with that obligation. Just think about that. When the industry was putting together hundreds of millions of dollars worth of loans and promissory notes, they never intended that a thief could pick up that promissory note, march into court with it, and throw you out into the street. That is not the way this was set up from the beginning. It was set up from the beginning that the note and the mortgage were two documents, inseparable, traveled together, and that they were assigned together along with the rights and obligations of the parties to that transaction that were executed from the beginning. We're talking primarily about the pooling and servicing agreement, 300-page long document that lays out with specificity all of the terms and conditions and the rights and the liabilities of all those parties to that transaction. Understand that this was not a document intended to protect a borrower. These documents were produced to protect those big business interests from one another. And yes, the borrower is a third-party beneficiary of those because we have rights under those documents. But the fact of the matter is that when the banking and financial services industry collapsed, And when they walked around with pieces on the ground, they could no longer effectively or efficiently operate under the rules that they created at the beginning. So rather than do things correctly and come to court and admit that things were a problem, they decided to engage in this lie that the promissory notes are negotiable. And so you have all across this country plaintiffs walking into court with original promissory notes endorsed in blank and asserting that they have a right to throw Americans into the street. It's an absolute lie. Courts need to push back against this, and I'm inclined to think they will, frankly, based partially on what I see coming out of the 4th District Court of Appeals with this Elston versus CW Capital opinion, and then another one just released yesterday as well, Rigby versus Wells Fargo. It stands, these two cases in the growing body of case law stand for the basic proposition that if you as a plaintiff are going to come into a courtroom and throw an American into the street, you better do so with a little bit more than just an original note, the squiggly signature on the back of a promissory note. You simply have to come to court with some additional evidence that proves your right to do so. This is a matter of national security again, because we have billions of dollars worth of capital and interest in property floating all around this world, and nobody has any idea who really owns these things. There are corporations out there that are failed, that are bankrupt, that don't have the right to pursue these cases, and yet they're being allowed to do so in courts all across this country. There are loans that are being pledged multiple times into trust, so you have multiple entities claiming interests in promissory notes, in mortgages, and if you're not attacking the alleged ownership of note or the alleged right to pursue these things, then you're not effectively representing the interests of your clients or, frankly, standing up for the rule of law and protecting our courts from this incursion. Now, there's also the case recently reported in the Fort Lauderdale Sun-Sentinel where a law office asserts, and this is asserted in the law in the article, where a spokesman for the law office asserted that they were retaining original promissory notes as part of their dispute with their former clients, I believe. Now, think about that. I find it particularly disturbing that in this state where these plaintiffs have pled that they weren't able to find promissory notes routinely for years, we know now that that was false pleading. I took depositions recently, and the representative of the bank indicated that the systems that they have can track with almost perfect accuracy the placement, the origination, the location of promissory notes from origination until the foreclosure sale, and it just stands to reason. A promissory note is like a $100,000 check. You don't just lose this thing. They don't get lost. In fact, if a promissory note leaves a vault, and understand that after a promissory note is originated, it travels to a vault. It sits in that vault. Part of what's spelled out in the pooling and servicing agreement in all of these transactions is what it takes to get that note out of the vault. Specific procedures of custody and control. There has to be forms filled out that go from the person requesting the note to the vault. When the vault holder, the custodian of those documents, retrieves that document, there is tracking when it comes out of the vault. There are tracking numbers that are placed on that original note, including shipping tracking numbers. There are bailee letters that go with that original note, and there are insurance policies that go with that note. So these promissory notes were almost never lost. It was one of the biggest lies that's been perpetrated to our courts all across this country, that hundreds of thousands, or in fact millions of promissory notes were lost. They were not lost. And yet they were allowed to perpetrate this lie again and again and again. And continuing today, they're perpetrating the lie that notes are lost, and that they're filing affidavits of lost note that are lies. Now, the case law that's coming out of our appellate courts makes it clear that you have to prove your standing at the inception. If you're going to travel under this lie that you're the holder of a promissory note, you have to prove up that you were the holder of the promissory note prior to the date that the lawsuit was filed. Now, holder, in quotes, is a technical term. In many, many, many of these cases, these plaintiffs could never prove that they are a holder because they could never fit the specific legal definition of holder. These two cases are very important to me because just today I've got a house going to sale. It's one of my first, frankly, only losses of a foreclosure sale of a family living in a property. We had a long trial on this, and some of the specific issues that I raised in this case were standing at the inception, were the failure of the plaintiff to prove that they had the right to sue and throw this family out into the street. I objected strenuously. I objected in pleadings and affirmative defenses from the beginning. I objected in motions for directed verdict at trial. I renewed those objections. I put them on record again and again and again, over and over again. I was overruled. I lost the case. The House is going to sale today, and just yesterday, these cases come out of the 4th DCA, which affirm those fundamental principles that I shouldn't have lost, frankly. So, of course, we'll be filing that appeal, and frankly, every attorney out there should be carefully considering the state of agency principle law and attacking all of these cases based on this. Now, here's another huge point. We now understand that in the vast majority of these foreclosure cases, the named plaintiff up there is in fact not the plaintiff. Or they may have some interest in the proceeding as a servicer or whatever else, but they do not own the note and mortgage. The fact of the matter is that Fannie and Freddie, or the federal government, own the vast majority of foreclosures that are notes that are being foreclosed on all across this country, and yet they're failing to plead that. They've been hiding behind this lie, what we call the wizard behind the curtain. The wizard behind the curtain is the federal government in many of these cases, and the wizard behind the curtain are foreign interests that own pools of notes. They are the real party in interest, and the nominal plaintiffs are just standing up there foreclosing to throw Americans out into the street on behalf of foreigners who own these notes and mortgages, or the investors in these trusts. It's up to all of us as attorneys to be making these challenges all the time, that they are not the real party in interest, and force them to plead these things properly. Take a look at these two cases here that I'll attach to the video, and keep fighting and pleading these things out.